Hello, I'm Bart Basie. I'm a CPA and attorney, hold a doctorate in accounting and business economics from Indiana University. And with that, and about $4, you can buy yourself a cup of coffee. You'll also notice on the screen on the first slide there that we're going to talk today about estate and business succession planning. You might say, well, Bart, why are we doing this? We're wanting to file tax returns. This is important because not just filing a tax return for a client, you should know about that client. You should know what that client's, how that client's going forward, whether the client has done any estate, has done any succession planning if they've got a business, for example, and what the family situation is. I mean, it's amazing how many times that I and my firm have gotten involved with an individual or with a family on one particular matter, and then all of a sudden you find out, well, gee, Bart, I don't have this, I don't have that. Just recently we helped a business. We were called in and helped the business determine what they were worth. Three brothers owned the company. And then all of a sudden, one brother says, Bart, this affects my estate, doesn't it? I said, well, yes, it does. And he said, well, gee, I don't have a will. And then all of a sudden, we got into estate planning. So this is what is called an added value to your clients. If they know that you're not just going to ask them a series of questions, you're not just going to gather information from them, put it in a file for the tax return, but you and I both know how much we know about that client. We know how they make their money. We know how they spend their money. We know what their expenses are. We know what their investment is because if they've got dividend income, if they've got interest income, if they've lost money in the stock market, if they've buy and sell antiques, if they go to dog tracks and try and lose gambling money and want to take deductions, you'd be surprised how much you and I know about our clients. It's a lot more than anyone is willing to acknowledge. And because of our knowledge of our clients, we are in a prime position to give them and help them with some estate and succession planning. And you should take that opportunity. We're not investment advisors. I will never tell someone how to invest their money. I will never tell them what to do as far as investment strategies are concerned. I'm not registered. You're not registered. But we can talk to our clients about whether they've got an estate, what the documents are that they need, whether they should have some succession planning in a little business that they've got or their family owns or that they operate in, or if they're an employee, how they should handle it. So that's the purpose of this program. As a matter of fact, if you look at slide number 2, you're going to very clearly see I've identified some of the value-added services you can provide to your clients by understanding this, okay? And it also includes retirement stuff, what we call 529, all right? Gift tax returns that you're going to file. Especially, you'd be surprised how many times when you ask your client certain questions, it'll come up that, oh, wow, well, I've given this away to this person, or I've transferred that, or I want to do this, and they've not filed a gift tax return. Even if taxes are not due, that doesn't mean a gift tax return is not required to be filed. And that can obviously lead to more business for you and for me, okay? And we talk about client retention. We want to keep clients. We don't want them to come in one time and that's it, they're gone. I don't like clients who come in to me and say, help me file their tax return, and then I don't see them for another year. And then I find out when they come back in the following year, all that's happened during the year. And I said, well, why didn't you call me? They said, well, I didn't know you did that work. You'd be surprised how many people contact me or speeches I give around the country. And I'm available to give speeches and presentations and workshops all over the country for businesses, for clients, for accountants, and so forth. But it's amazing. People will say, well, I didn't know you did that. If we don't explain that to people, you'll lose it. So client retention, loss of actual business, okay? So please keep this in mind as we go through this program, okay? And there's potential for your filing estate tax returns, decedent's estates, gift tax returns, especially gift tax returns, and also trusts. Matter of fact, we're going to talk a little bit about trust later on in the program, but it's also interesting to know that a lot of times trust tax returns are not filed. I'll ask a person, well, you've prepared a trust, or your attorney drafted a trust for you. What kind of trust is it? Is a tax return required? Well, they have no idea. Would you believe I had recently gotten called by an individual who owns a business? He asked me for a totally unrelated matter. He asked me for something to do with business. He said, Bart, can you stop in? He says, when you're in town, he said, I'd like to talk to you about something I'd like to do for my sister. I said, sure, I'll stop in, I'll talk to you. Name was Doug. I said, Doug, I take 2 minutes. No problem. I stopped in, talked to me. He said, well, Bart, he says, I created a trust. I said, you created what? When did you create a trust? He said, well, he says, I thought that was the best way to do something. So I talked to a local attorney and he created a trust. I said, well, what kind of trust is it? He said, I don't know. Well, what's in the trust? He says, well, I don't know if anything was actually put in the trust after you created it. Can you get me a copy of the trust so I can see exactly what it was? It's amazing when I found out a trust had been created, no tax return had been filed or ever filed to acknowledge the return, the trust. That property was never put into the trust to begin with, but he's always been considering it that this property was in the trust. So it's a tremendous avenue for you and I to work with clients. Let's make sure we understand the definition of estate planning, okay? What is an estate planning? The needs and actions of what someone's going to do during their lifetime, not at their death. And it's too late. During their lifetime, okay? And keep in mind, it involves not just, I'll notice on the bottom of slide number 4, there I got 3 items. It's not just wills or trusts or powers of attorney or insurance. It consists of the entire concept of everything under the word under control. As a matter of fact, when I used to teach at the university, I used to tease my students and said, you're going to forget a lot of what I tell you. But one thing I want you to remember is a key word. Whenever you're dealing with estate planning, the key word is control. The federal tax law, the Federal Internal Revenue Code of the United States says that if you have an element of control, that asset is going to be included in your estate when you die. Let me just mention insurance for a second. It's up on slide number 4, just quickly. People say, well, insurance is not taxable. Well, now wait a minute. If there's an element of control, then insurance can be taxable. Now, you got to be very careful on how it's handled. I had a situation come up a few years ago. I couldn't understand it. A lady contacted me. Her husband had died in a helicopter accident. I felt, very sorry. I said, ma'am, how can I help you? She said, well, she says, my husband owned a company, and the company received a $4 million life insurance policy payout when my husband died. I wanted the money, so they gave me the money. They're telling me, however, I've got to pay income taxes, federal and state, on that money. And the federal and state taxes amounted to excess of 30%. Well, 30% of $4 million is $1.2 million in taxes. And I says, I got to check this because insurance proceeds should not be subject to income tax. So we checked. This was a subchapter S corporation. There was a key man policy. Now, subchapter S's do not pay taxes. The company received the money. It is not taxable income. It was passed through as a distribution to the spouse. There was a mistake made on the tax return, and the mistake resulted in excess of $1.2 million in taxes. Major, major concern, major problem. But again, that's because the sub S owned the policy. And sub S's don't pay taxes, as you and I both know. But if that policy was owned by her husband personally, and he had a control element, paid the premiums on it, named the beneficiary, could change the beneficiary, then for estate tax purposes, that $4 million could have been included in his estate. So keep in mind, when we talk about insurance, we're talking about the person who purchases the insurance versus the beneficiary. The beneficiary pays no income taxes on the proceeds. But the person who buys the insurance, if they have an element of control over the policy during their lifetime and up until the instant they die, then that policy proceeds can be included in their estate for estate tax purposes. Okay? So knowing that, let's go through this and see how you should start this. as far as I'm concerned, the very first thing you should do is create an estate plan organizer. You might say, Bart, what's an estate plan organizer? An estate plan organizer is a document. Type it up. We have two of them. We have one that's a short form, one that's a long form. Ask your client, by the way, this helps you for income taxes as well. Get family information. Find out if the person's married, if the person has children, if there's any other sources of income, what their concerns are, what their insurance proceeds are, or what their insurance policies are, if they've got retirement programs, if they've got alimony payments that are being made, if they've inherited any money. Find out about their family. Find out about their property. What's their general level of income? Where are all their sources of income come from? Get this not just for your income tax return, get this by filling out a form. Now you don't have to, a lot of times we give a form to the client and say fill it out. They don't fill it out. So a lot of times what you need to do is to have a meeting with them. You charge them a nominal fee and say, look, it's going to take us an hour. I need to ask you a series of questions so I can find out about your family, about all the property, about your finances, and about any business. Find out how they spend their money, how they invest their money. Not that you're going to be an investment advisor. And like I say, in my firm, we've developed a short form and a long form. The short form is for individuals who are employees, who have very small levels of income, who don't have a big problem as far as their wealth is concerned. And so we know that they're not going to have 4 pages of insurance policies. Okay? We know that their medical coverage is a certain category. So we don't bother them with a 20-page questionnaire. But then we have clients who have some wealth. And we know they do some investing because we file their income tax returns and we see dividends coming in. And we see the different sources of income. Or they own a business. Okay? Or they're retired and they're living on different sources of income. And we have a little longer form. And obviously if some pages in the long form don't apply, don't worry about it. You don't have to prepare 2 documents, but I would strongly recommend that you prepare a document. And if you don't want to call it an estate plan organizer, simply call it a client plan organizer. You should have one for every one of your clients. What we do is we have every client who comes in to us to file an income tax return the first time, we go through all about their family, all about their property information, all about their sources of revenue, their expenses, and any businesses that they're involved in casually by the family. We have some businesses where 2 brothers run it and a sister lives out in California, but she's got a 1/3 owner because her father left 1/3 to each, to her and her 2 brothers, but they run the business. So we would have never known that had we not asked her. So develop some written organization plan, make copies of it, hard copies, or in today's society you can put on your computer. But I would strongly recommend that you have it done and you spend about an hour of the time with every person that comes in to file your taxes so you can learn about them. This is due diligence. And then every year, pull it out and update it. As a matter of fact, what we do in our firm is every year, when the client calls and we make an appointment for them to come in, we usually send them an update sheet and say, we would like to know if there's any changes in the family structure, any family changes in the property information you provided last year, or finances, or your business. Bring this information with you when you come in, or you can send it in to us ahead of time. People like that. As a matter of fact, we've had some clients who've asked us to make copies of our or client plan organizer so that they could have a copy for their files, and we have no problems passing it on to them. As a matter of fact, you'd be surprised how many law firms that are doing their wills or trusts love the fact that we've got this organization. It saves them time and it saves your client money. Okay? Also, you can work with local attorneys and other professionals by having information, and your client will say, can you talk to them? Can you explain this to them? And this is, again, not done, in a lot of cases, not done for free. So please be aware of that, okay? But this is something that I highly, highly recommend for your clients. Let's go ahead and talk about some of these documents. Not necessarily, you're not going to prepare them, okay? But documents you should be aware of so that if the family calls you, you'd be surprised how many people come in and file a tax return and they say, Bart, you know all about me. If anything happens, can my spouse call you? Or I talked to a farmer recently, getting on in age, and his wife was getting on in age with him. And he says, Bart, he says, and this is in his living room. And he had his niece in the living room. He says, Bart, I want my niece to meet you. If something happens, or when something, unfortunately, all of us are going to pass away sometime, okay? I hate the word expire. We're going to die, all right? People need to know where to go. They need to know what documents have been prepared. They need to know what your thoughts are and what your plans are. And by the way, this is something you ought to do for yourself as well, okay? You've got a business. I've got a business. Do you have your own succession plan, okay? Very important to have it. So when I talk about this thing, I want you to be aware of some of these factors, okay? So let's talk about a will just for a second. Everyone obviously should have a will. The estate tax returns, a 706 type of thing, we're not going to talk about that. We're simply talking about what a will is. You've got to have your clients make sure they name an executor. You'd be surprised how many wills I look at where they don't name someone who's going to handle their estate. What to do with their property, okay? Whatever assets, whatever property is not distributed during their lifetime, how should it be distributed at death? You might say, well, Bart, is there more than one kind of will? Yes. Would you believe? Let me just highlight a couple things. We have one that's called a non-culpatory will. That's a will that is simply verbal, or it's been dictated to someone. And today with the computers the way we have them, you can talk to your computer and it can save in your computer what you have. As a matter of fact, I'm going to tell you something about computers in a little while with estate plans that even I wasn't aware of until recently. And it's made a major, major impact, and states are passing laws on it. I'm going to hold that up in a second. But I want you to be aware that there are some wills that are actually in computers now that somebody just has dictated. And if you can verify the fact that it's their will and they can explain it to you, that can help you an awful lot. There's also wills that are called holographic wills. Holographic wills are will that's handwritten. I laugh when I say this because I've got some elderly people who say, Bart, I don't want to spend money on an attorney. They say I can do this myself, so I wrote my own will out. This is just what I want done when I die. I want this person to get this. I want this person to get this. Here's where I'm going to be buried. Here's where I've made my plans with my religion and so forth. And it's just handwritten, okay? Ideally, we like to get someone to witness it, okay? In some states, we want 2 witnesses. Other states, 3 witnesses, okay? But, you do have wills that are handwritten in today's society. Not that they're the best, but seriously, at least they've committed to writing, both if it's verbal and dictated to someone or if it's handwritten. At least they've got something. And if someone talks to you, and I don't care how low in income they are or how wealthy they are, you'd be surprised. I've been a university professor for years, and I find that in my travels and in my research and in studies that have been showed, they claim less than 20% of our population have written instructions on what to do when something happens to them, okay? We also have what is called nocturnal wills. If you deal with military personnel, okay, or if you're in the state of Louisiana, these are wills that are they're in public form, okay, and they're prepared by what we call civil law notary publics and so forth that are allowed to do them. They're typically done in the military, and they're done in the state of Louisiana, I believe, okay. There's a will called a mystic will. Fortunately, I've never had these in my own practice, but a mystic will is a will that's written by someone that's closed and sealed, and no one is allowed to look at it until that person dies. It's sealed until death. So I'm sorry to tell you, if your client tells you, well, I wrote a will, but I've put it in a sealed envelope, it's in my safe, or it's in my drawer, or it's under my underwear, my second drawer, my closet, or something, whatever the case may be, but I don't want anyone to look at it until I die. It's valid. It's not that it's not valid, okay? As long as it's, signed properly. But it's interesting Okay? Then we have what is called a serviceman's will, active duty service personnel. If there's a problem with them and there's a situation, they can have a will made immediately and have it handled. We have what is called, and I come across this a lot, and this bothers me. They're called reciprocal wills. You have a lot of times when a husband and wife have been married a long time, and they say, let's make one will. Now, you know, my wife and I have been married, hate to say this, but a little over 54 years. And she's got a will, and I've got a will. The wills might be complementary, but if I die, she can change her will. If she dies, I can change my will. If you have spouses prepare one will, that's called a joint will, okay? They both sign it. Are you aware that if one spouse dies, it is illegal for the other spouse to change the will? It's a legally binding document the first time the first spouse dies. I strongly recommend, if you should talk to one of your clients, or you should have a client form, you know, the estate planning form that I talked about earlier, and you ask them, do you have a will? What kind of will is it? Well, what do you mean, what kind of will is it? Well, did you write it? Did you have an attorney draft it? Is it notarized? Is it written somewhere? Is it sealed and put away somewhere? Ask them a series of questions that you don't have to identify these by name or by title. Is it one will? Is you and your spouse? Do you have one will, or do you each have separate wills? Okay. Obviously, I'm a firm believer of separate wills. Okay. Not that I'm going to change my will if my wife dies, but you can never tell. And not that my wife wouldn't change her will if I died. You can never tell. The idea is a jointly written will that we refer to as a reciprocal or mere or mutual will becomes a legally binding document that cannot be changed once one of the spouses passes away. Okay? Not recommended. Okay? Then you have wills, and I mentioned this at the very beginning, where they forget to name an executor. Who's going to handle the will? Well, I want this property done here, I want this done there, I want my burial done here, I want my taxes paid here, but they don't say who's going to do it. And then you have an argument in the family as to who's going to be assigned that. You've got to go to court, or someone's got to go to court and get the court's permission. Yes, you can be the executor or the administrator of the will because there's no executor named. And by the way, I've got to be careful, and I apologize if I've offended anyone. We no longer use the word executor because we used to call a man an executor, a woman an executrix. Nowadays, the proper terminology, and let me just make sure I'm on record correcting myself, the proper terminology is a personal representative. A personal representative is the individual named in a will. You might just make a note of this because I know that some of us have been practicing a long time and we have a tendency to go back to terminology that we've used in the past. And today, again, when you talk to someone, an elderly person, say, who's your personal representative? They may not even know who you're talking about. But today, when we write wills, when we deal with individuals, we don't talk about an executor or an executrix. We refer to the person who is responsible to handling the will as either a personal representative, that personal representative is named in the will, or an administrator. An administrator is someone assigned by the court to handle the estate. Okay? So let me make sure I correct myself as I'm going through there. Obviously, a will that's drafted by an attorney, that's signed, that has at least 2 witnesses, that's notarized, the witness signatures are notarized, okay, is the best that you can have, all right? Not that it can be changed. Remember, we refer to this as an executory contract. I know a lot of clients have asked me, Bart, what do you mean by executory? Executory is a contract, and it doesn't have to be a will. Any kind of contract that doesn't go into effect the day it's signed, it goes into effect in the future. A will that's properly documented goes into effect when the person dies. So it's a contract, but it's not effective until they die. That means executory contracts can be changed prior to them becoming effective. We sell businesses, we transfer assets, and we say, I'm going to sell you this asset in 6 months. I'm going to buy this house in 9 months. We're going to close in a year and 4 months. Those are called executory contracts, okay? So a will is an executory contract. Keep in mind, wills can be changed up until the day of death. All right, so be aware there's different types of wills, but this is something that you should talk about your client. Now, let me tell you something that's happened in the United States. This is something that Bart Basie learned recently. Never stop learning, by the way. Digital estate planning. People's estates are going digital. Now there's tax laws that have been passed. Are you aware that I found out that there are now 19 states in the United States, and there's 10 more states that are considering this law. There's a law that a committee wrote called, and let me make sure I get this down right, it's called the Revised Uniform Fiduciary Access to Digital Assets Act. 19 states have passed this law. 10 more states are considering it at the time I'm doing this program. And you might say, Bart, what the heck is this law? Well, this is the second bullet point on slide number 7. It says uniform laws regarding this. This is what this law is. It's a revised uniform law. Okay? It says that a will can allow the executor, I use the old terminology, personal representative, to access all of their communications. For example, suppose I have information, emails, and other information on my computer. I can now direct in my will that I want my personal representative handling my will to erase everything in my computer. I don't want anyone to see it. Or I can have a statement in my will that says, make sure that everything in my computer, everything in my emails is transferred to Mr. Smith. That this becomes his property. Not just the computer guts itself, but the programs that are in there, the information that's in there. It is amazing what now has cropped up. Now, I got to tell you, this law excludes any stock accounts, any stock brokerage accounts, or any bank accounts. Because bank accounts and stock brokerage accounts have got to be included in the state tax return, so you cannot tell someone to destroy those records, okay? But this act specifically says we are in a digital age. And this digital age can allow an executor, personal representative, to have access all of our digital communications. The iPad, the phone, the telephone. It's amazing what we have. Matter of fact, I don't know why we call them phone. We should call them personal information gadgets. I mean, I use my phone for more things than you can imagine. Okay, not just for making a phone call is one of the few items I use on it. Okay, it's a camera, it's a lot of things. So be aware. And your will, remember the last bullet point on slide number 7, your will can now order the destruction of any or all communications except, okay, stock accounts, brokerage accounts, and bank accounts. All right? And it's not illegal. It's now allowed. Again, I'm just going to make sure we say this, okay? 19 states have passed this law, 10 more states, which makes a total of 28 states. 10 more states are considering the passage. I'll make one other statement, okay? The act allows for the person to direct that their fiduciary delete or eliminate any and all communications, and additionally, you can decide if you want to offer your heirs access to specific communications. You can state that in your wills. So nowadays, when my office writes wills, we're licensed attorney in several states. When we write wills for people, we now have to explain to them if their state has passed a law, they can designate who gets their personal communications, who doesn't get their. Okay, I've got an individual up in the state of Minnesota who says, Bart, I've got 2 email addresses. One's personal, one's business. My personal one I want destroyed. The business one, I don't technically own, it has to stay in the business. So we have specifically written that his personal representative will destroy all elements on his personal email. He does not want any family members to know what's on that, or anyone, as a matter of fact, to know what's been on that personal email account. Okay? Not that it's illegal information, but be aware that we now have a law that specifically addresses this issue. And I'm telling you, when the law came out, I was surprised that so many states started jumping on the bandwagon. Okay? Let's talk about powers of attorney. You have powers of attorney that are typically not considered part of the estate plan, but it's something you should know about, because a power of attorney can be for property, it can be general, it can be health care, whatever the case may be. There can be different types of powers of attorney. In some states, there's this interesting law, and you should know this in your particular state. In some states that I've been in, I have found that when a power of attorney is drafted, it becomes effective immediately. So what some attorneys do is they'll draft the power of attorney, they will keep it in their office, because a person drafting a power of attorney may say, wait a minute, if I can't make my own health care decisions, if I can't handle my own money matters, I want Mr. Smith to handle them for me. But I don't want Mr. Smith to handle them until I lose my mind, if I can't make my own decisions. I'm incapable of making my decisions. But some states allow that power of attorney to come into effect immediately. So if Mr. Smith gets a hold of that power of attorney, that Mr. Smith or Mrs. Smith or Miss Smith can make decisions on my behalf when I may not want them to do it. And then I got a legal battle. So please be careful. One last thing with regard to powers of attorney, and this is something important for you to know, because if a person is not mentally capable of making their decisions, and you've got to file their tax returns, you've got to know who holds the power of attorney to be able to sign and take responsibility for the tax returns. My mother's passed away now, but several years ago when she was alive and she got dementia, very difficult for her to make or remember decisions she was making. And I had the power of attorney. My brother and I had a power of attorney. And so we could make the decisions for her. And the bank and other organizations accepted it as long as we provided them a copy of it. So if you're dealing with anyone, make sure if they say they have a power of attorney, POA they write after their names, make sure you receive a copy and put it in your files. I do not want you ever to get caught by saying, well, someone told me they were the power of attorney, and so I let them sign the return. Please receive a copy of the POA, the power of attorney, and put it in your file. So at the time you are aware that that power of attorney, that person was legitimate. Very, very important. I would have never done anything for my mother without giving the person, the bank, the doctor, whomever, the hospital, whatever the case may be, a copy of the power of attorney to verify the fact that I did have the power to make those decisions. It was effective at the day I was applying it, okay? And I tell this to my clients as well, all right? Very, very important, all right? I would not recommend a client have one power of attorney to cover everything. I like to have a general power of attorney that can't handle money. If there's real estate involved, a separate power of attorney, obviously a separate one for health care. In one situation, we had a client who trusted her daughter to make her health care decisions, but did not want her daughter to manage her money. She was afraid her daughter and the daughter's husband would use all the money, and her other children wouldn't get it. And she had several children. So we had a health care power of attorney that named the daughter to take care of her mother's health care, but we had one of the sons have the power of attorney for handling all money matters. Now, obviously, if the daughter incurred an expense on behalf of the mother in taking care of the health care, the son made the decision to pay the bill. Okay? So please be aware the same person doesn't need to be named in each document. Okay? Not that you're going to write these documents, but you're going to come across these documents in dealing with clients, and I want you to be able to understand what it is. Let's switch to another thing.